Mr. Arias. All right, good afternoon, everyone. Is Mr. Romero over at the main jail? I don't know where your client is.
Yes, Judge.
Mine's
I've-
De La Paz.
Ivan De La Paz, that was a reset from this morning. Is he there?
That was a different facility, right? I think it was a different facility, Judge.
Okay. Is that Mr. De La Paz? All right. Ivan De La Paz over at Paul Ryan?
We need the Spanish interpreter this morning on him.
Did he? He needed the Spanish. Mr. Arias, he needs a Spanish interpreter, or are you going to, because I believe that's what they said this morning.
I can wait. I think Mr. Reedy said that you guys said there was one coming up.
Well, if he called, I don't,
I just heard a door open.
Mr. Reedy, oh, there's the Spanish interpreter. You are right on time. All right, do you swear or affirm to interpret from Spanish to English and English to Spanish?
I do, Your Honor. Can you please see court interpreter?
All right, Ivan De La Paz
Iván de la Paz
is before the court today for an additional charge.
está ante el tribunal por un cargo adicional.
It's a sexual assault by custodian.
Es acceso carnal violento por un custodio.
And
Is it a change of charge?
it's a add
¿Es
charge,
un cambio de carácter o es un cargo agregado? Es un cargo agregado.
right? How many, so this makes number 4.
Así que esto sería el cuarto cargo.
And what are the other 3 charges? Are they
¿Cuáles son los otros
similar?
tres cargos?
Count one was the same charges as count four. Count two was a VSP that is receiving RR. And count three is an infringement.
Okay. So he
El
has
primer
a,
cargo es lo mismo que el cuarto cargo. El segundo cargo es violación de probatoria que recibió libertad bajo palabra. Y el tercer cargo es una petición de detención por inmigración.
and the charge number 1, did he have a bond?
Y el
Okay,
primer cargo, ¿él tenía fianza? No, está siendo detenido sin fianza.
Your Honor, I believe that Alex Arias, on behalf of Mr. De La Paz, we didn't have the opportunity to be able to argue a bond as to this case, as to the first one.
Su señoría, el señor Alex Arriaza, de parte del señor de La Paz, yo creo que no hemos tenido una oportunidad de poder debatir el tema de fianza para el primer cargo.
you have the findings from the first time?
Your Honor, I know that Michael Spear on behalf of the state, for the record, I know that Your Honor did find proof evident presumption great on count 1. So the state would be asking to just keep that in place.
I'm sorry.
So I don't believe I have a probable cause affidavit in front of me to go over the facts at this point.
No, that's not,
Your Honor,
right,
if the interpreter may interpret
right.
for each.
Sorry.
Thank you.
Oh, man, I have to apologize too. Sorry. I should know better.
You should.
¿Hay algún visto de parte del juez, de la jueza? Michael Spears, de parte de la Fiscalía, entiendo que su señoría dictaminó la primera audiencia que había prueba evidente de gran presunción. La Fiscalía quisiera mantener eso como está.
Your Honor, the problem that I have with that, which we've had it with magistrate court before, is the finding of proof evident presumption great. I won't even be able to bring it up in court. I'd have to appeal to the court.
Oh,
This is what, I've
No.
had this issue with this particular judge that were in front of Lynch.
this is
and
a,
Coleman.
this is a preliminary finding of proof evident presumption grade. If you look at the case law, Isaza versus State, it's a preliminary finding of proof evident presumption grade without prejudice for him to have an author hearing before his division judge. That's exactly what the case law says.
Su señoría, el problema que tengo aquí con esta prueba evidente de gran presunción es que no se puede debatir en el tribunal. Yo tendría que presentar una apelación, especialmente con este juez, que es el juez Lynch, y la jueza intervino y dijo, no, esto es un visto preliminar, y de acuerdo a Zaza versus State, contra el Estado, esto se puede ver ante el juez del caso con una audiencia de Arthur.
And I have that all the time with attorneys tell me that they've already scheduled their bond hearings after I make a preliminary finding of
Y
proof
siempre
evident
escucho de
presumption
abogados
great.
que los abogados ya han fijado audiencias para fianzas una vez que está ante el juez de división, después de magistratura.
Your Honor, I'm not questioning you. The problem is I've had this issue over, I've had it a few times. Once magistrates, there's a finding of proof evident presumption great. I agree with you with the case law, but that's why I tried to, if there's just no bond, but once there's a finding of proof evident presumption great, that's, and we didn't have. Fight, an evidentiary.
It's not an evidentiary hearing at a first appearance. That's what I'm saying to you. It's,
I'm saying, I agree, Your Honor. What I'm saying is, that was the only, that's the issue that I have with that finding. But Your Honor says the case law
no, you're right.
is what it is.
No, la cuestión es que me ha ocurrido un par de veces cuando la magistratura dictamina que hay prueba evidente de gran presunción. No, pero su señor, yo concuerdo con usted, pero con la jurisprudencia. Pero cuando se dictamina ya en magistratura que no hay fianza, ves que no es una audiencia evidenciaria. No hay nada que probar aquí.
Your Honor, I'll bring up the issue from the Judge Lynch.
Okay. I was looking for a copy. I thought sometimes I bring extra copies with me, but I don't, so,
Case law?
yeah.
Su señor, voy a presentar el caso ante el juez Lynch. A veces tengo ciertas copias de la misma jurisprudencia.
Your Honor, if it becomes an issue, then
Right, then, you know what to do.
I'll bring it back up.
Si se convierte en un tema que hay que ver, entonces yo lo voy a volver a presentar. Usted sabe qué hacer.
All
I've
right,
just always had the argument, I know the case law that you're talking about, but on two cases, they said that I had to appeal it.
Yo conozco la jurisprudencia de la cual usted está hablando, pero en 2 casos se me dijo que tenía que apelarlo.
all right, so for today, I'm sure if there, I will make that preliminary finding of proof evident presumption great and hold Mr. De La Paz no bond on this charge number 4.
Así que para hoy, para la audiencia de hoy, voy a mantener ese visto de prueba evidente de gran presunción y voy a continuar para el 4º cargo deteniendo al señor De La Paz sin fianza.
And this is without prejudice for him to have a bond hearing.
Y esto sin prejuicio para que pueda él celebrar una audiencia para la fianza,
Based on State v. Arthur
basado en el Estado contra Arthur,
before his division judge.
ante su juez de división.
Your Honor.
Okay. Yes, sir.
I apologize. I haven't
Yes.
seen you in a long time, but I don't mean to be argumentative. The problem is you just cited Arthur. Arthur allows them to keep them under the Arthur, with the Arthur hearing.
No,
You just made a,
no, I made a preliminary finding that says it is without prejudice for him to have an Arthur hearing if he wants to. No, it's not pursuant to Arthur. No, he can have an Arthur hearing he can have an Arthur hearing if he wants to. That's the finding. This is, my proof evident presumption grade is not based on an Arthur hearing. That's why it is without prejudice for him to have an Arthur hearing. Okay.
Su señora, simplemente quería clarificarlo, no es que quiero ser compatible con usted, pero no, es que la jueza corrigió que es una audiencia que no es preliminar, que es sin prejuicio, o sea que él puede celebrar la audiencia de Arthur.
It's good to see you, Mr. Ariaza.
nice to see you.
Is there anyone else who needs the Spanish interpreter?
Yes, Judge, there's 2 here at Maine. One of them is on page 11 of your docket. His name is Mr. Irvin Palma, and the second individual is on page 12, and his name is Mr. Luis Perin. Señor Palma, ven por aquí, por favor.
Irvin Palma?
Yes, sir.
All right, Mr. Palma, you're before the court today on charge 1, possession of cocaine.
Señor Palma, está ante el tribunal hoy el primer cargo, posesión de cocaína.
Number 2 is operating without a valid driver's license.
El segundo es operar sin licencia válida.
Number 3 is a traffic infraction not for magistrate.
Y el tercer cargo es una infracción de tránsito que no es presentado ante la magistratura.
I find probable cause.
Dictamino que existe motivo fundado.
Judge, at this time, I'm gonna be asking for a phone order so he can access his phone contacts, to contact his family, post his bond.
En este momento, señor, estaría peticionando para una orden judicial para que tenga acceso a su teléfono, para que él pueda contactar a su familia y puedan arreglar el tema de su fianza.
I'll sign that order, and
Yo
he has a $1,000 bond.
Yo firmaré esa orden y él tiene una fianza de $1,000.
All right, Luis Padin.
He's approaching, Judge.
It has, and he has 2 no bond holds as well, though. All right, so Mr. Padin is before the court on 1 charge of grand theft.
El señor Padín está ante el tribunal por un cargo de hurto mayor.
Charges 2 and 3 are violation of felony probation with no bond holds.
Cargos 2 y 3 son violaciones de probatoria de delito mayor sin fianza.
I find probable cause,
Dictamino que existe motivo fundado.
and I've been advised that the bond on 1, which is $1,000, has been posted.
Y se me ha informado que la fianza para el cargo 1 de $1,000 ya ha sido pagada.
The other 2 violation of probations are out of Miami-Dade.
Las otras 2 violaciones de probatoria son del condado de Miami-Dade.
Okay. All right, anyone else with needs a Spanish interpreter?
No one here at Main, Judge.
Okay. And hearing nothing else from,
Nobody as far as I'm aware of, Judge.
okay, all right. All right, thank you. Have a good weekend. All right, Counselor, you're here on Shaquille Brown?
I am, yes, Your Honor.
All right, good afternoon. Shaquille Brown on page 11.
Mr. Brown, come on up, please. Your private attorney, Mr. Apianis, is there present. Right there. Good morning, Apianis.
All right, so Mr. Brown, you're before the court on charge 1 is failure to redeliver hired or leased vehicle. Number 2 is illegal use of credit card 2 times or more. 3 and 4 are felony violation of probation, right? And those have no bond holds. And you're scheduled to see your division judge next Tuesday, October 1st at 8:30, okay? All right, so I find probable cause, and I'll leave the standard bonds in place, okay?
Yes, ma'am.
All right,
Okay.
all right, good
I'll
luck.
come see you tomorrow, okay?
Alright.
All right, Delta Estin,
Judge, she's here, but she's gonna require a Creole interpreter.
We have one on the way.
okay?
Have a seat, ma'am.
Saward Michelle,
She's approaching, Judge. She's here at Main. Come on up, ma'am.
all right, Miss Michelle is before the court on 1 charge of trespassing, and I find probable cause.
Judge, I'm gonna be asking on this nonviolent offense if the court will consider an R1 on Miss Michelle's behalf. Before I proceed, I'll see if the state has an objection.
All right, I'll RR Miss Michelle, okay?
Thank you.
All right, Cynthia Roberts,
North Broward, Judge.
Ms. Roberts is before the court on 1 charge of dealing in stolen property. Number 2 is false owner info for pawn items. I find probable cause.
Judge, can we check if
Your
her bond is
it-
posted?
It has been.
It has been posted.
Your bond has been posted, ma'am.
Thank you.
All right, Linda Urena,
Miss Lorena had the same question, Judge, if her
has
bond is
Miss,
posted.
has Miss Lorena's bond been posted? Miss Lorena, while they're checking, you're before the court with 1 charge of possession with intent to sell, manufacture, or deliver cocaine. It has been. I find probable cause, and your bond has also been posted, okay?
Thank you.
All right, Robin Lewis. Robin Lewis. Oh,
He's here,
All right,
President.
Mr. Lewis, you're before the court, because there's an out-of-state felony hold with a no bond hold is out of the state of Colorado. So next week you should be going before the extradition court. Okay? William Hennigan,
He's approaching, Judge. He's here, man.
Mr. Hennigan is before the court on two misdemeanor capuses. The municipal ordinance violation charge, the capus was issued September 5 of this year, carrying an open container. And then the other capus was issued because you did not show up for a hearing, and on that charge, it's a trespassing charge. All right, so I find probable cause, and what does Mr. Hennigan want to do?
Judge, Mr. Hennigan advised me he was here recently, I believe about 2 weeks ago, and he advised me he thought he resolved these matters. So if he didn't, he wishes to resolve these matters today.
All right. Does anyone have any information about, Steve, do you have an offer for Mr. Hennigan? Do we know?
One moment, Your Honor, let me pull that up and see if the assigned prosecutor is.
Okay. Do we have information that he resolved cases 2 weeks ago or recently? The name is familiar. He doesn't look the same. I think he did something.
Your Honor, the state's offer on the trespass, 192969 MM40A, was a withhold, court costs, and no return.
Okay. Thank you.
Thank you. But they have to talk about the count one. Yeah. So listen to the judge.
All right, so it is not showing that these two charges were resolved, so,
I'm not
Because-
showing that, Judge.
okay, all right. Because that's what he said, that's what you said at the beginning, that he thought he had resolved these cases. So
Yes.
I had someone checking to see if that was the case.
Oh, I thought the prosecutor just confirmed that he
Well,
resolved the withhold.
Well, he offered that's his offer to resolve the case today.
Oh, I thought that's what he received. Okay, so let me tell that to Mr. Hennigan. I
Okay,
explained to Mr. Hannigan in reference to count 2, that was not the case. He did not resolve it. I did inform him of the state's offer, and he wishes to accept the state's offer.
and also confinement is confirming that he resolved another MO recently, not this one that's before the court today.
I explained it to him, Judge, and as a friend of court, on that one, he wishes to resolve it. as
All
well.
right, so if you wish to resolve these cases, then I'll sentence you to the same sentence, withhold adjudication and court costs.
Thank you.
All right, then please raise your right hand, Mr. Hennigan. Do you swear or affirm to tell the truth?
Do you swear to tell the truth? Yes, I do.
Okay, you can put your hand down. And do you understand everything that we've discussed here today?
Yes, I do.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
I understand.
Understand that there's going to be no more investigation on this case. Do you understand that?
Yes, ma'am, I do.
And that you're waiving your right before the state has, they already filed the charges. So, have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, you may be subjected to a deportation or immigration changes?
I am, but I am a U.S. citizen.
Okay, what plea do you wish to enter at this time? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is a withhold adjudication court cost. Good luck, sir. All right, Reginald Wilson,
Mr. Wilson, come on up, please. Municipal ordinance, Judge.
yes. It has? Okay. All right, Mr. Wilson, you're before the court on a municipal ordinance violation for trespassing, and I find probable cause. And sir, I've been advised also that your bond has been posted.
Okay, thank you.
All right, so you need to check and make sure that you know when you have to come back to court.
All right.
Tracy Washington,
Mr. Washington, come on up, please. He's approaching Judge CRMA.
all right, Mr. Washington, you're before the court on charge number 1 is a traffic infraction. That's not for magistrate. 2 and 3 are misdemeanor capuses, and that judge issued $250 bonds. And 4 and 5 are also traffic capuses, and also on those, the judge issued a $500 bond on each of those. It looks like you have court next Tuesday and Wednesday on both cases.
And Judge, Mr. Washington gave me the phone number of his mother. I intend on calling her after court places monetary bond.
All right, so we'll leave the standard bonds in place. All right, Julian Bocanegra.
Mr. Bocanegra, come on up, please.
All right, Mr. Bocanegra is before the court on a traffic capias. This was issued September 17th of this year. The charge is driving while license suspended, and I find probable cause. I don't have a court date for Mr. Bocanegra.
Judge, it's me, Mr. Bocanegra. He wishes to resolve this matter today.
All right. Well, here's the driving while license suspended. Here's the consideration. I don't know what is, has he resolved anything previously on driving charges? Because now we have some new law coming down next Tuesday, and I don't know if this has any effect on, or can have any effect on him.
Looks like he did have a DUI that he resolved. It was at 2018.
Okay,
But I don't see any other driving charges.
okay. All right, if he wants to resolve, you have an offer for him?
Could I check if the assigned prosecutor's made an
Sure,
offer?
sure.
See any prior offer at this time? State would just offer adjudication time served.
Okay.
Judge, he wishes to accept the state's offer.
All right. All right, Mr. Bocanegra, with the information that I have today, it's just that you had one prior DUI, and then if it's correct that this is gonna be a second, was he convicted on, he was convicted on the
Yes.
first DUI?
DUIs are mandatory.
All right. I'm just thinking about the new amendment on the laws, Mr. Romero. And I'm still trying to figure out what they mean by conviction, but 3 convictions, the 3rd conviction, there's a mandatory 10 days jail, even whether it's a felony or a misdemeanor. It can either be a misdemeanor and with 10 days or be charged as a felony. So that's why I have those questions for him. And I don't know, what's in his past, except now that they've told me that he has a DUI. So with all of that, do you still want to resolve your case today? The new law goes into effect October 1st.
Judge, he so wishes to proceed forward.
All right, so Mr. Bocanegra, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And do you understand everything that we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
I understand.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Understood.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves adjudication, time served. Good luck. We have the Creole interpreter. Oh, is she at,
Main judge. She's
oh,
here.
okay.
Miss Esteen.
All right, Ms. Sinaj, if you'll raise your right hand, do you swear or affirm to interpret from Creole to English and English to Creole?
I do. Vivian Senage.
All right. Delta Estin,
Delta Esteem? Yes.
you are before the court today, ma'am.
Ou nan tribunal lan jodi an, madame,
One charge of resisting officer without violence,
pou yon akuzasyon kote reziste on ofisye san violans.
and the other charge is trespassing.
E lot akuzasyon se kote entre yon kote ilegal.
Do we know, did you have an opportunity to speak with Ms. Destin? Ms. Estin?
I did, judge.
Oui,
All
mte
right.
pale ave li juj.
And I find probable cause. What does she want to do?
Mjwen koz probab, ki sa li vle fe?
Judge, she's financially indigent. She is homeless,
Li pa gen kay kote pou l rete, li indijan,
and she has no one to contact to help post her bond.
e li pa gen moun pou kontakte pou ka pou ka ede l soti nan prison.
She informed me that she's been residing here for me for the past 10 years.
Interpreter need repetition?
She's been residing in our community for the past 10 years.
Li fe konen ke li lap viv nan kominote a pou 10 an,
And she has no one to contact to post a monetary bond.
e li pa gen piyes moun pou kontakte pou te ka bay l'ajan pou soti nan prison.
So at this time, we're going to be requesting an ROR on Ms. Esteen's behalf, Judge.
Alors, pou le moment, nap mande pou jus la gel sou prop engagement li.
I am inclined to sign an order to transfer her to Judge Lerner Wren's division.
Map siyen yon lot pou transferel bay juj le Neuren.
And that's based on the probable cause affidavit.
E sa se baze sou dokumen sa ki yo ekri nan koz probab la.
Which states she's in the business yelling at employees.
La pantre nan da boutik, la prele sou travaye yo.
And it doesn't seem to be for any reason. It's just that that's what she was doing.
E pa semble ke gon rezon ki fe la fe sa.
So, I am going to leave the bond in place,
Alors, m'a quitté caution an toujou même,
and
montant,
I will transfer her to Judge Lerner Ren's division.
et ap transféré nan division juge le Neuren.
Okay.
Ok.
Does anyone else needs a Creole interpreter?
Est-ce que gen l'autre moun qui besoin interprète créole?
Thank you. Thank you. Have a good weekend. James Gordon.
Judge, wait, before the Creole, Jonathan
Oh.
just raised his hand.
Miss
Sir,
Enosh.
what's your name?
She heard.
What's your name? Frankie? Frankie what? What is it? 1 minute. Oh, Frankie Fallison, right? Yeah. Okay. He's here, President Judge, at page 8.
What's his name? Frankie Fallison? Oh. All right. Frankie Falliston,
Frankie Folestin?
Yeah.
you are before the court for charge one is DUI, alcohol, or drugs.
Ou devan tribunal lan pou 2 akuzasyon, yon se ko tap kondwi sou,
2 and 3 are traffic infractions not for magistrate.
2 avek 3 se tiket sirkulasyon.
I find probable cause.
Mjwen koz probab.
Judge, at this time, nothing to add. I'm going to be contacting Mr. Fallison's mother to post his monetary bond.
Ma pral kontakte maman li pou l ka peye kosyon an.
All right. He has a $500 bond.
Li gen yon kosyon pou $500.
Okay. All right. Anyone else for the Creole interpreter?
Est-ce que
Last
gen lot
call.
moun pou kreol?
Creole? No, Judge.
Okay.
All right. Thank you. All right. James Gordon.
He's approaching, Judge. Is your name?
All right. Mr. Gordon is before the court on a traffic KPS. This was issued December of last year for an unlawful license tag or sticker attached. I find probable cause.
Judge, and speaking Mr. Gordon, he wishes to resolve this matter.
Okay. All right.
State's offer was a withhold court costs.
Okay.
Judge, he wishes to accept the state's offer.
All right, Mr. Gordon, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, I do.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you, sir?
Yes, I do.
You understand, is anyone forcing you to resolve your case?
Not.
And you understand that you do have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes, I do.
Do you need any more time to speak with your attorney?
No, I don't.
And you understand that, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes.
I'm a U.S. citizen, Your Honor.
And have you ever been treated for mental or emotional illness?
I have emotional illness.
And is there anything about that illness today that would prevent you from making a decision?
No, it's not.
All right, then what plea do you wish to enter, Mr. Gordon? Guilty or no contest? I accept your no contest plea. I find that it's freely and voluntarily given. Your sentencers withhold adjudication and court costs. Indel Saintville.
Stand up, come on up, please. He's approaching, Judge, your name.
Good evening, Mr. Saintville. You're before the court on one charge of resisting officer without violence. And number 2 is a misdemeanor KPS. That capias was issued March 11th of this year. The charge there is possession of cannabis 20 grams or less. I find probable cause.
Judge, I don't know how much cannabis is alleged to have been involved in this. The Odyssey doesn't have a copy of the probable cause affidavit, and it's not mentioned in the warrant where Mr. Sandville was arrested. It appears that this case took place back in March. But the reason I ask is 'cause it seems like the state's position is going to be that anything under 3 grams of cannabis is not going to be filed.
Right.
So I don't know if it was 3 grams or less at this point. I don't have that information.
I don't know.
And Judge, pursuant to that, Judge, I was gonna ask the court if on count 2, the misdemeanor cannabis, I just wouldn't want him pleading to something that eventually the state's going to not file. My understanding, I believe the facts surrounding that case of, I believe he was initially stopped for riding a bicycle without a light, and then I believe subject to a search, which the officer claims that Mr. Samuel gave him permission and cooperated and gave him permission. That's where the cannabis was found, but it doesn't say an amount. So I'm gonna be asking on Mr. Samuel's behalf if the court would consider an ROR on count 2.
All right, I'll grant the ROR. And he has
Judge,
a,
in count 1, he wishes to resolve that.
all right. Well, the first thing I'll say is, wait, confinement, do you happen to have that probable cause affidavit on the capias, on the possession of cocaine? You don't have the file? All right, so the thing I'm gonna say to Mr. Saintville is that, this has been since March, and, you've gotta make sure that, one, either that you keep in touch with your attorney, I don't know if you had an attorney before then, that you keep in touch with your attorney so that you know when you have to come to court, because I'm telling you that, this judge issued a capias with $1,000 bond. And, just because of, we don't know, technically how, the weight of the, cannabis at this time.
Probable cause affidavit, Your Honor, doesn't contain.
It doesn't have it. All right, so I'll ROR him, and then what does he want to do now?
In reference to count 1, he's seeing if the court has a plea offer for him with the state.
Okay. But, I mean, I know he has this other charge.
Has a
Okay.
good number of misdemeanors, Your Honor, and in 2014, there was a felony petty theft and burglary conveyance. Looks like he did 22 months prison.
All right, I'll sentence him to adjudication, time served.
Judge, he wishes to accept the state's or court's offer.
All right, please raise your right hand. Swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And, Mr. Saintville, do you understand that, today you're only resolving the resisting without violence charge? Do you understand that?
Yes, ma'am.
And that you still have a pending, possession of cocaine charge at this time?
Cannabis.
I'm sorry, cannabis.
Yeah, yes, ma'am.
That you're gonna have to come back to court on that charge. You understand that?
Yes, I understand.
All right, is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol?
no, ma'am.
Do you need any more time to speak with your attorney?
No, I got no time.
All right, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter at this time, sir? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication, time served. Good luck. Borislav Protsenko.
I've been informed he's a medical reset.
Mr. Protsenko is a medical reset. Thank you. Gerald Walden.
He's approaching. Judge is here in Maine.
All right, Mr. Walden, you're before the court on a misdemeanor capias. This was issued April 10th. The charge is possession of cannabis, and that you have $100 bond on that charge, okay?
Judge, I have the same question on Mr.
I
Walden.
figured, so I'd leave the bond in place at $100.
Judge, would you consider an ROR on his behalf?
Well, what does
It's the
Mr.
only thing.
What kind of history does Mr. Walden have?
So one moment, I was looking at the probable cause affidavit to see if it says an amount. Let me check his history. Misdemeanors, and then case in 2010, he had a possession of cocaine where his VOP or his probation was revoked. Did 16 months. In 2011, he had an aggravated assault with a deadly weapon. Looks like that was the same sentence of 16 months.
Okay. All right. That's the only charge on that paperwork? Is that the only possession of cannabis is the only thing there on the KPS? Yes. All right, I'll grant the ROR, and Mr. Walden, it's the same information, sir. You need to make sure that you stay in touch with your attorney, or you check the clerk's office to make sure that you don't miss court again. The charge is not dropped, so you understand. Maybe it will be, but at this point in time, you still have a pending case, and you need to go to court. Do you understand that?
Yes, ma'am.
All right. Austin Houston. Mr. Houston bonded. All right. Regis Bovin.
Mr. Bowman, come on up, please.
All right, Mr. Bovin is before the court. Charge 1 is DUI, alcohol, or drugs. Number 2 is DUI with a breath level greater than .15. And number 3 is a traffic infraction not for magistrate, and I find probable cause.
Judge, at this time, nothing to add. We're just going to be asking the court to sign a phone order so he can access his phone contacts to call someone to post his bond.
All right, I'll sign that order, and the standard bonds are in place. Bobby Wade.
Mr. Wade, come on up, please.
Okay. All right, so Mr. Wade is before the court on 1 charge of disorderly conduct. Number 2 is failure to obey police or fire department. I find probable cause, and your bond has been posted.
Oh, it's been posted?
Robert Wiener. Robert
Mr.
Wiener.
Weiner is a medical research judge.
Mr. Weiner is a medical reset. Arrington Edwards.
Mr. Edwards is here present. Come on up, sir. He's approaching, Judge. He declined the services of public defender. He's going to hire his own private attorney. Terrence Benjamin. Come on up, sir. Benjamin. Terrence Benjamin.
Mr.
right, Mr. Edwards. Sir, you understand that you are entitled to counsel at this time?
Yeah, I just told him if I could, once I burn out, I know if I'm gonna hire a public defender or get my own attorney.
All right,
But I have a job.
so you don't want to make that decision today? Is that what you're saying?
I don't really know what's, you know what I'm saying? I don't really know. If I burn out, and cause I have a job, you know, I could probably save up some money, and, well, cause I have a job.
Well, no one can make that decision for you, so I need to understand today, right now, if for this hearing, if you are going to use the attorneys from the public defender's office, or if you are going to represent yourself.
Well, today I use him. Well,
Judge, you want to put this on recall?
I will.
Thank you.
Terrence Benjamin,
Mr. Benjamin, I've been calling that name, Judge. Oh, bonded, Judge, bonded. Sorry.
okay. That's why he's not answering. He's left.
I'm sorry.
All right, Willie Ross.
Mr. Ross is here present, Judge, in Maine. He's approaching.
All right, Mr. Ross, you're before the court today on one charge of robbery by sudden snatching without a firearm. And then number 2 is aggravated assault with a deadly weapon without intent to kill. And I find probable cause. Does Mr. Ross have any priors?
Yes, Your Honor. There's a number of priors dating back to 1987. Looks like most of them are drug-related. However, there have been violations of probation. There's been a good amount of prison time, but I don't see anything else violent.
Okay.
There's a couple misdemeanor batteries.
All right, what's the state recommending for bond?
The state's recommending $10,000 bond. It's based on the facts of the case, as well as no victim contact and no possession of any weapons.
Okay. Mr. Romero?
Judge, as far as the special conditions with this state is requesting, we have no objection to that. However, I believe they're requesting a total of $10,000 bond. That's something that Mr. Ross is not going to be able to afford, nor his wife. Now, he's been living in our community for 40-plus years. He's 59 years old. He's on disability. He got $775, so the only person that can post his bond is his wife. She works as a security guard at a school, and from what he informed me, she's not going to be able to afford that much. We're going to be requesting a $1,500 bond and one $1,500 bond too, so that'll be a total of $3,000, which we're requesting, Judge.
Is a Texas Hold'em a card game? Yes, Your Honor. Okay. All right, Mr. Ross, I'll impose a $1,500 bond on 1 and 2. No victim contact, no weapons or firearms. And no return to playing Texas Hold'em.
Yes, ma'am.
All right.
Good luck, sir. Thank you.
All right, Keon Boucher.
Mr. Boucher is approaching, Judge, and he declined to serve as a public defender. He's representing himself. Mr. Kenny Williams, come on in, please.
All right, Mr. Boucher. Good afternoon, Mr. Boucher.
Kenny Williams.
Your Honor, I feel like I'm a victim of police brutality. On last night, I was
Well,
pulled over.
it sounds like you need an attorney. Everything that you say here today is being recorded and can be used against you. And so at this time, I encourage you not to talk about your case, but I was gonna say unless you speak to your attorney, but you don't have a private attorney here, and I guess you're refusing the services of the public defender's office. Is that
The only
correct?
reason why I did is because I was told that I wouldn't be able to explain what happened to me yesterday.
Okay. Well, for today's proceedings, I am fine determining probable cause and setting your bond. You will have a time to have a hearing, whether it's a motion to dismiss or a motion to suppress, at another time. That's not for today,
Okay.
all right?
Well, I feel like the charges that I'm up against are padded charges, Your Honor, because I asked the officer that pulled me over to speak to his supervisor. I didn't resist arrest, nor did I refuse him. All I simply stated to him was, could he have his supervisor arrive to the scene due to the fact that he wasn't aware as to why he was pulling me over. When I asked him why he pulled me over, he told me it was because I ran a red light, which was invalid. He had came out of the gas station and got directly behind me. And at that time, when the light turned green, he turned on his lights and pulled me over. Unfortunately, it was a police sting on that same street.
I'm still
and
telling you that you're saying a lot of things that today is not going to,
relevant.
is not relevant today.
Okay.
That's what I'm telling you. Today's not the hearing for that.
Okay.
So you're gonna say all of that, and it's gonna be on the record, and they're gonna be able to use it against you, and I don't know which way the argument is gonna go. So,
Okay.
so what you need to tell me now, since you're representing yourself, is how much bond you can afford. Do you have a job? Those are the things that you have to tell me at this time.
I currently do not have a job, man.
All right, State, does Mr. Boucher have any criminal history?
Not that I could find.
All right. I'm sorry, what was that? I'm sorry. Mr. Romero, can you help us to turn that mic off for a little bit so I can hear over here?
Sorry.
No, that's okay. Yes, ma'am. Okay. All right, so Mr. Boucher, I will ROR you to pretrial supervision, sir. That way you don't have to pay a bond, but you have to report to the pretrial office on Monday morning. I'm going to ask someone over there to give you the information.
I do apologize. You were referring to this coming Monday?
Yes, sir.
Okay.
Yes, Monday morning, you need to go to the pretrial office and sign up. It's standard pretrial. So you need to make sure that you're there by 9 o'clock and sign up with them, and they will give you the instructions as to how you call in. And then you can file what, you'll see if they file the charges, and then if they do, then you get to have your day in court. Okay?
Okay.
All right. Kenny Williams.
He's here, present, Judge.
All right, Mr. Williams is before the court. Charge 1 is burglary, unoccupied conveyance, unarmed. Number 2 is loitering or prowling. Number 3, resisting officer without violence. Number 4 is a traffic infraction not for magistrate, and I find probable cause.
Judge, Mr. Williams, my understanding is this is his first time being arrested in his life. He is 19 years old. He's been living in our community his whole entire life. Right now, he's actively looking for work. He lives in West Park with his sister. His sister goes to college and is working at Wendy's. So right now, she really doesn't have the financial resources to post his bond. If the state can verify this is his first time being arrested, I would request that the court consider releasing him ROR. If not, Judge, we're going to be asking the court to consider releasing him under supervision of pretrial release.
Okay. Any priors of Mr. Williams?
Yes, Your Honor. It looks like there are a number of juvenile priors.
Okay.
A lot of juvenile priors.
Okay. Yes? All right. So we have to make the same type of charges. We have to tell people that, you know, even juvenile priors are priors. So All right, so I am going to impose a $1,500 bond on one. It doesn't go away, it follows you, all right? And no return to that location. Dwayne Webb,
Yes, Your Majesty.
all right. Mr. Webb is before the court on one charge of robbery firearm. Number one, numbers 2 and 3 are aggravated assault with a deadly weapon without intent to kill. Number 4 is touch or strike battery. Number 5 is a traffic capias. I find probable cause for these charges.
Does appear, Judge, as though the firearm in this case was actually a plastic gun.
Yes, I do see that. The firearm was located on scene and determined to be a plastic gun replica. Well, as to, well, it's not a firearm on one, but as to 2 and 3, does it have to be the, what does the statute say? Does it have to be the actual weapon, or does they have to believe that it's a weapon? For aggravated assault with a deadly weapon. Oh, it's assault, so
Right.
it's what they believe. All right, so for one, I will make a finding for robbery, no firearm. Well, that's what they have, so I'm not. All right, so, and then I find probable cause as the other charges as stated, so. All right, so state,
Just one moment, Your Honor.
sure.
Weapon in this case was not an actual firearm. Just due to the seriousness of the facts of the case, as well as what appears to be, while not a complete admission, at least a pretty relevant statement by the defendant himself, the state would be asking for $7,500.
Okay. All right,
Judge, I didn't hear what the state was asking for bond.
well, that's on one, right?
Yes, Your Honor.
$7,500 is what he's asking for on one, and I guess he's saying he's deferring to me for the other ones?
Yes, Your Honor.
Okay.
Sorry.
No, that's okay.
Judge, in speaking to Mr. Webb, unfortunately, right now, him nor his girlfriend are really in a position right now to financially post much of any sort of financial bond. Now, he's been residing here in our community his whole entire life. He's 47 years old. He is working, but it's part-time at the Port of Everglades. He's only making about $16 an hour. Now, his girlfriend was working. She was working basically as a crossing guard, but unfortunately, right now, she had to take a medical leave of absence. They've been residing in the same location locally in North Miami, renting an apartment. They don't own, they rent. And their monthly rent is about $1,200 a month. But right now, because of his girlfriend's medical issue, right now they're kind of behind on rent. They're going to be facing eviction pretty soon. They really don't have any sort of financial resources to post bond. He will adhere to whatever conditions the court imposes on him. But right now, financially, he has basically no financial resources.
All right, I hear that, but here's the allegations that I have to work with today. A defendant entered the store with his face covered, wearing sunglasses, and that as the defendant entered the store, and even though we find that it was not a real gun, He pulled up his shirt to display a handgun in his waistband and stated, "Don't be stupid, open the register and give me all that SHIT." And it was at this time that they entered the store. There's another victim who entered the store and began fighting with him. And they both struggled with him and was able to, until police arrived and to take him into custody. So he did go in, the allegations are that he went into the store to rob the store and did give them the impression that he had a gun and that he would use it. So I find that Mr. Webb, based on these allegations, gives me cause for concern for the community. I am going to, on charge number 1, enter a $7,500 bond. And as to 2 and 3, the bonds will be $2,500 on each count, 2 and 3, and then the other standard bonds will remain in place. No return to that location, no victim contact, and no weapons or firearms.
Judge, in speaking, Mr. Webb, he wishes to address the court. I did advise him, however, not to talk about the facts of the case. I think he assured me he's not going to talk about the facts of the case.
Okay?
Exactly, I will not talk about the facts of the case, but, Your Majesty, 2,500 on those last two. Once again, I'm not a threat like that. I understand you're reading the facts, and it sounds like that. I hear people over there laughing and all. I had some situations going on, okay? And just like he did say, the young lady who I am with, she just got off medical leave. She was a crossing guard. Port Everglades, the boats are not coming in. The season is it's just bad. So we're not getting any work. And I have 2 little kids, step-kids, and we're about to get evicted. Things are getting bad. I haven't been in trouble since 1991. I'm 47 years old. I haven't been in trouble since 91. I understand you probably don't even have any of my records to look at how I've been scoring out. I haven't been in any trouble. I made a dumb decision, and I'm not looking for a justification for what I did, but please look at those 2,500s right there. I understand you did give me a slight break with the 7,500. That's $750. But ma'am, I'm already in the barrel trying to get back out. I made a dumb decision, and I realized that was a stupid decision to make. But please have some kind of mercy on those $2,500 bonds. You're making it a little more steep for me, man.
All right, Mr. Webb, I think based on your argument, you've made it steep for yourself. So these are the bonds and they're gonna remain in place, okay?
Okay.
All right, Obinson LeBron. Mr. LeBron is before the court. Charges 1 and 2 are felony capuses, and those have no bond holds. 3 and 4 are kidnapping, and number 5 is committing a first-degree felony with a weapon. And I find probable cause. We'll hear from the state. Sure.
Three and four, the state would ask that Your Honor find proof evident presumption great and hold the defendant no bond.
Objecting to the court making that finding at this time. The state has not introduced any evidence or presented any witnesses in this case. Apparently, there are a number of witnesses, and yet the state, for whatever reason, has decided not to call them. Since the state has failed to do that, we would argue that they have not met this very high burden of proof evident presumption great. And we would ask the court at this point in time to set bond for Mr. LeBron.
All right, I've reviewed the warrant and the affidavit that supports the warrant, that was issued by Judge Fine. And based on that, I am going to make a preliminary finding of proof evident presumption grade as to 3 and 4, and hold Mr. LeBron no bond until such time that he's able to have a bond hearing before his division judge. And I'll leave the other standard bond in place on number 5, and it looks like he has court on Tuesday in his felon division at 8:30. Okay? No victim contact, sir, no victim contact, which means no phone calls, no text messaging, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
All right. All right, Ariel Bonilla.
Please hear, President Judge.
All right, Mr. Bonilla is before the court on, there's 3 court orders. It shouldn't not be for magistrate, right? Because he was taken into custody yesterday on these charges and held no bond on all counts. All right, so that just remains as his division judge did yesterday, okay? All right, are we ready to address Mr. Edwards?
Not yet, I'm right now talking to him, just need a couple more minutes, Judge.
All right. Do we have persons at the, on the, where's our hearing docket?
Few in North Broward.
And one at the county, Your Honor.
All right. Who do we have at North Broward?
Holder, Your Honor.
Who's Holder?
Yes, Your Honor.
Page
Sean
3,
Holder.
Felony docket.
Okay, on the felony docket. And what was the, let's see, do I have information on Mr. Holder? All right, so Mr. Holder has a $5,000 bond, $5,750.
Yes, Judge, he's not able to post that bond. He has been living here all of his life, and he does have prior contact with the criminal justice system. He's trying to change his life around. He wants to get into the House of Hope. He says that they'll take him back. I have not been able to confirm that. But if they would, Judge, give me a minute. Let me make another call over there.
Yeah, the issue, I think, with Mr. Holder is that he was arrested on September 22nd on a charge of grand theft auto and reckless driving. And then he bonded on the 23rd, on the 23rd, and then on the 24th, he's arrested again on these same charges. That was the issue, because I was looking to see why I increased the bond. So I'm not gonna make any changes today. I'm gonna leave the bond in place,
All right.
all right? All right, who else do we have at North Broward?
That's it for North Broward, Your Honor.
All right, thank you.
Thank you. Your Honor, County has one.
All right, Conti has 1. Who's the one at Conti?
Your name? Raul Mahone, man.
All right, Mr. Mahone, he's on page 2 of the felony hearing docket. He was arrested on August 25th. Is this a 30-day motion?
Your Honor, I believe the information is actually being filed today, if it hasn't already been.
Well, the question is it filed?
One moment to check.
25th is the 30th, so you're at the 32nd day.
Yes, Your Honor, and information's already been filed.
It has been filed?
Yes.
All right. All right, Mr. Mahone, the state is, was it filed as charged? Felony petty theft?
Felony petty theft, yes, Your Honor.
Okay. All right, so, Mr. Mahone, the information has been filed on your case. What this means is that now you'll go before your division judge for an arraignment and for any other matters moving forward, okay? All right. That was it for Conti, Deputy?
Yes, ma'am.
All right, have a good weekend. And then Paul Ryan, who do you have, Deputy?
Yes, Your Honor, I had two on there. One decided that she was gonna wait for her bond to be posted, and she chose not to come up.
Who
And
is
the
that?
second one
Who is that?
wanted me to let, that was Miss Marshall.
Lisa Marshall? All right,
Right. Yeah, she said her parents were in the process of paying the bond.
all right, so that's
Okay.
fine. And who's the other one?
And the other one is Miss King wanted me to relay to you that she's not waiting, you're taking too long.
Oh, wow. All right, well, then I don't have to make any ruling. That's how that works, okay? All right, Deputy, thank you.
You're welcome, ma'am.
All right, there's always a first, huh? You're not waiting, you're taking too long. Right, she could have resolved her case. Or she really didn't want to have anything to do with us today.
Judge, whenever the court's ready, I don't know if the court's waiting on me.
It's all about you now, Mr. Romero.
Oh, wow. Okay, Mr. Weiner, come on up, please. No.
All right, who do you have? Mr. Edwards? Who's this?
Mr. Edwards is here first.
Okay. All right, so, I found probable cause, and, what does, on aggravated assault with a deadly weapon, what does, Mr. Edwards want to do now?
Judge, and speaking of Mr. Edwards, we're gonna be asking for the court to consider a bond at approximately $3,500. Now, from what he advised me, he's been living in our community his whole entire life. He's 45 years old. He lives here locally. He lives in Hallandale, Beach Boulevard, with his aunt. My understanding is his aunt has really no financial resources to help post his bond, so he's going to be reaching out to his girlfriend. Now, his girlfriend works, but she's a caretaker, and my understanding is like the first of the month is coming up with the rent. She's really not going to have the financial resources to post a very high bond. Now, he is working. He works at Steak and Shake, I believe, on Hallandale.
Hollywood, people who are from Hollywood.
And he's only making approximately $9 an hour. He will abide by whatever court conditions, and he will be coming back to court to face these allegations. He just wants an opportunity to fight these allegations from the outside. He believes if the court set somewhere in the neighborhood of $3,500, his girlfriend might be able to come up with that using the services of a bondsman.
Okay. All right, State.
Your Honor, the state would be asking for a bond of $10,000 with no victim contact and no weapons. And that's due to the facts of this case where he allegedly pointed a gun at the victim's head and stated that he would kill him. And he does have some priors. It looks like they're back mostly in the 90s, but there was an aggravated battery with great bodily harm and an aggravated assault, both of which he was in prison for 4.5 years for. I believe pre-trial stated that he is currently on federal probation.
He's on federal probation? Usually I get that, he's on federal probation until when? Oh. All right, Mr. Edwards, you have a $10,000 bond, no victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
All right. Okay. Who do we have left on our, let's see, on the misdemeanor docket, we have Mauricio Ortega.
He's approaching Judge May.
Mr. Ortega was arrested on September 22nd. Does he have 2 misdemeanor charges?
He has a misdemeanor, I believe, operating without a valid license, I believe, when he initially came in. I believe he had a felony case as well. My understanding is he resolved his felony case this week. He was given adjudication time served. He has an immigration hold. Judge, at this time, he wishes to resolve this matter. Even though he already resolved his felony offense and got a time served, I also did advise him that this could negatively affect his immigration status and lead to his deportation. However, he still wishes to resolve this matter today.
All right, so, right, when he came in, he had 3 felony cases with no bond holds, and those are the 3 charges that he's resolved? All right, so now all he has left is operating without a valid license? The bond is posted? So the bond was posted on the operating, and he, of course, he still has a no bond on the immigration hold.
Thank you, Judge.
All right. So we'll deny the RR. Well, the bond has been posted, so. All right, and then on our here felony dockets, we did Mr. Mahone, Samuel Randall.
He's approaching Judge May.
And Mr. Randall was arrested on September 24th. Mr. Randall has a $5,000 bond.
Correct, Judge. And speaking of Mr. Randall, unfortunately, there's no one that's going to help to post his bond. He is homeless. He's financially indigent. He's been living here his whole entire life. He's 25 years old. However, he did inform me he has a mailing address. It would be of his mother who resides in Fort Lauderdale. That's where he can make sure he gets future court notices to make sure to come back to court so he doesn't miss court. So we're asking for the court to consider releasing Mr. Randall on pretrial release.
All right, so I am going to deny that. My information is the information I had before. Was Mr. Randall was released from prison March of this year. And on this occasion, he's the driver of a vehicle that's stolen. He told the officers that somebody loaned him the car, but he couldn't provide any information. So I'm going to leave the bonds in place, okay, and deny the RO. All right, Jerry Dunbar.
He's approaching Judge May. Come on up, sir.
Good afternoon, Your Honor.
Good afternoon, Mr. Dunbar. Mr. Dunbar was arrested on the 24th. He's released to pre-trial.
Yes, we're
Level
actually in the process of trying to verify his address. He gave us the contact number for one of his friends who went to the house where he says he lives and found out that the brother is in the hospital. The friend is supposed to call us back with contact information for the brother, so that's what we're waiting for. They've been calling him, but he's not answering anymore.
Yeah, because my brother has bad sugar, And he had recently got out, but I didn't know he was back in there so soon.
As of this morning.
But
his
I
brother
do
went to
live,
the
I
hospital.
do live there. We live together. He moved with me because of his health. I was supposed to have been watching for his health. And I do live there for 6 years, maybe 6.5 years. I didn't know he was back in the hospital so soon. That's why I couldn't call him.
So who is this that you've been speaking to, a friend?
Sean Watson is the friend.
Uh-huh.
He said we called Sean to verify the address. He said he didn't know it, but it was a block over. So he went there. They called him back yesterday to verify the address. Couldn't get him yesterday, so they called him again this morning. He said he went over. The neighbor told him the brother lives there and the brother is in the hospital. So he was supposed to call us back with contact information for the brother and the actual address. So that we
Yeah, I know Sean Watson.
try to
He's like a
verify it.
brother to me.
All right.
I didn't know he was in the hospital, man. I'm sorry.
All right. So I will change it to standard pretrial. And, Mr. Dunbar, you need to make sure that you show up at the pretrial office on Tuesday morning.
I will, but I need to go straight to the hospital.
No, well, I understand that you may have concerns about your brother, but are you listening to me?
Yes, ma'am.
You need to go to the pretrial office on Monday morning, all right? If your brother is in the hospital, he's in the best place, so you need to take a few minutes, go to the pretrial office and sign up. If you don't go, a warrant will be issued for your arrest. Do you understand?
I will go, ma'am.
All right, and don't go back to this location. Okay. All right. So we'll change it to a standard pretrial. Michael Leaf? All right, and Mr. Leaf had a $2,500 bond.
Judge, initially, Mr. Leaf declined to serve as a public defender. He changed his mind, so I'm gonna, assist him today. Now, I know Mr. Leaf has a $2,500 bond on a battery and an officer. Judge, we're gonna be asking for the court to consider releasing him on pretrial release now. My understanding is, and obviously this is gonna be litigated at trial, whether it was, he was going through a medical crisis, Judge. I believe the allegations are maybe that he may have spit at a EMT or something like that to that effect. Obviously, right now, his health has gotten better. Judge, he's promising he will be coming back to court. He lives locally here. He lives in Dania Beach with his mother. From what he advised me, his mom cannot afford to post his bond. He works when he can at a labor pool. But Judge, there's really no one he can, or help him post a bond, and he can't post his monetary bond. He'll abide by whatever conditions the court sets, but he's asking if the court would consider releasing him under supervision today.
All right, I understand that, there is going to be a subsequent litigation, but here's what I have. And Mr. Leaf, I remember, said a lot of things, and I'm looking back at the probable cause affidavit, and yes, he was unconscious due to an overdose. They came, they revived him with Narcan, and then it says they placed him on a stretcher and into the back of the rescue truck. Then the firefighter who was driving the rescue truck at the front, while en route, the arrestee became irate with the victim and the witness. The victim was standing directly left to the arrestee, attempting to treat him. The arrestee then turned his head towards the victim and stated, "F you," and the arrestee then hocked up, cleared his throat, and spit at the victim, striking him in the pelvic area. And on arrival, the witness notified me of the battery. The arrestee was extremely non-compliant, verbally aggressive with the staff, and this officer upon his arrival. The arrestee was placed into custody for the offense of battery on a firefighter. Right? So, that's what I have to deal with.
I understand, Judge, and one
And-
other thing I just want to bring to the court's attention, my understanding is, he doesn't have a clean record, as far as, but the last time any sort of violent offense, I believe it's been over 10 years. Now, one,
No.
you get,
No.
no, violent charges?
He had a battery in 2018. Was a misdemeanor.
Because the
but-
information that I have is that he has a battery in 2018. June 2019, he pled to a resisting without violence.
Oh, you played with the, Judge,
So that was my, and I remembered, that was my concern with Mr. Leaf. There are a lot of things that he said that just didn't add up, and I am gonna leave the bond at $2,500, okay?
would you consider level 2? He was going through a medical situation, Judge. He was under the influence of drugs or alcohol. We wouldn't object also having him randomly drug tested. And with the level 2 monitor that might,
Where does Mr. Leaf live?
let the judge know where you live.
I live with my mother, Lisa Ann Leaf.
And so, you have a phone number for her?
Yes, ma'am.
Is that where you're gonna go back to stay?
Yes, ma'am.
What is her number?
954
Uh-huh,
549
uh-huh.
5493.
And what's her name?
Lisa Leaf.
Hello?
Good afternoon. This is Judge Jackie Powell, and I'm calling from court. Can I speak to Lisa Leaf?
Speaking.
Miss Leaf, good afternoon. Again, it's Judge Jackie Powell, and I have Michael Leaf before me today in court. And his attorney's asking if I could release him on an ankle monitor, and he tells me that he lives with you, and so we're calling to verify if that's correct.
He can stay here.
Okay? All right. So, I will release him on a ankle monitor through pretrial supervision. I guess they'll have to call you, after this to verify further information. But I wanted to make sure that, that was okay. Okay?
Okay.
All right, thank you, ma'am, for answering, and, I guess you'll hear from him soon.
Okay, thank you, Judge.
All right, you're welcome.
Alrighty.
All right.
Okay. Bye-bye.
All right, level 2, pretrial supervision.
Thank you, Judge.
Thank you, Your Honor.
You're welcome. You need to take care of yourself.
I'm gonna join. I want to know if I'm allowed to join JC's recovery hours.
You can.
I need help.
You can. You can do whatever you need to do, but you need to let the pretrial officers know what you're doing.
And I want to get help with my addiction. I got a big addiction problem.
All right. Well, take care of yourself. All right, Javed Ayube. Bonded? All right, everyone. It has been an exciting week. Thank you, and I'll see everybody next week. Oh, that's right.